My name is Barry Hines. I'm a sole practitioner with offices in Springfield, Illinois. I'm going to speak today on the subject of boundary line disputes and the applicable law. Boundary lines in the state of Illinois were created by the original government survey, which started in 1806 and concluded in 1843. Those lines are still the law today. Notwithstanding global positioning satellites or other apps that you may have for your handheld devices, those old surveys, recorded and platted, are binding on us. If we do not know where the true line is, the Illinois Supreme Court says there are 5 ways that we can solve that problem. 1, adjoining property owners can exchange deeds. 2, they can enter into a written agreement, which of course would take it out of the statute of frauds. However, they cannot enter into a written agreement if they know the true boundary line. Only the exchange of deeds will work in that situation. If the line is truly unascertained or disputed, there's 3 remaining alternatives. 1 is a parole agreement, followed by possession in accordance with that agreement. A parole agreement is an oral agreement. Next, it could be an implied agreement based upon the declarations and the acts of the parties over a period of considerable time. And that would be 20 years, we know will work, possibly less, but still it would need to be a number of years. The last is adverse possession. We have a statute in Illinois, we've codified adverse possession. It takes at least 20 years, and there are 5 factors that are important in establishing adverse possession. 1, the possession has to have been continuous and uninterrupted. It must be adverse and hostile. It must be actual. It must be open, notorious, and exclusive. And finally, the adverse possessor must act as if it were their property, totally inconsistent with the rights of the true owner. Those factors must be proved with clear and unequivocal evidence. The presumptions are with the true owner at all stages. It is a difficult test that one must accomplish to obtain title to property through adverse possession, but that is the last alternative we have. Let's speak for a moment about the agreements, the parole agreement or the implied agreement. As a condition precedent to those, there must be a disputed line or an unascertained line. In other words, we don't know where the original government survey starting point is or where subsequent surveys take us from that starting point. If there is an agreement, the agreement must come after the dispute first arises. In other words, the agreement is there to resolve the dispute. Those are the prerequisites to an agreement, either orally or by implication of law. If there is an agreement, however, that agreement will be binding on the parties and their successors. 2 points to remember. If it is a parole agreement, that agreement must be followed by possession in accordance with the agreement for a number of years. And if it is an implied agreement, it must be followed by acquiescence to that agreement. In other words, the parties' acts and their conduct must be in accordance with the line that they have agreed to by implication. Perhaps an example is best to explain an implied agreement. There is a case, the McLeod case, Illinois Supreme Court case, in which 2 owners of 40-acre quarter sections, were adjacent to each other, and they had abided by a hedgerow as their dividing line for a number of years. That hedgerow was taken down. After it was taken down, after planting each year, they put up an electric fence to contain their cattle during the winter months. And that electric fence was put up where the old hedgerow had been. In 1955, new owners came into title, and they decided, one of them did at least, the plaintiff in the case, that the original government line should be the boundary. And subsequent trial on that case, there was testimony from farm tenants and the men who took down the hedgerow as to the location of that hedgerow with certainty. They knew exactly where it was. The court found that there was an agreement by implication by the acts and the declarations of the parties over that number of years. The hedgerow had been up for over 20 years, the electric fence for some 6 years. That is an illustrative example of what an implied agreement would be. Lastly, a few remarks on the subject of adverse possession. Adverse possession has to be adverse and hostile, but that does not mean ill will. It simply means that the adverse party is treating the property as if it were their own. Their acts and their deeds are such, they're that of an owner, as opposed to a person who is out of title. Must be for 20 continuous years. Must be without permission. If it is a possession by permission, then it cannot be adverse. The proof, as I think I have mentioned, must be clear and unequivocal. It is a high hurdle to jump in order to obtain property through adverse possession. Very last thing I want to mention to you is we do have a statute in the state of Illinois, the Permanent Survey Act, which provides that if adjoining owners agree to a survey and a surveyor and enter into a written agreement with a copy of that survey recorded, both the agreement and the survey recorded, they can establish a boundary line in that manner. One can also petition the court for a panel of surveyors. However, a very important thing to remember, you are merely finding the original government line. You cannot create a new boundary. You must be binding by the government survey performed back in the 19th century. For more information on Illinois boundary disputes and law, please view my full presentation recorded during the Hot Topics in Agricultural Law program, now available in the ISBA online CLE archives. And to learn more about the benefits of joining our ISBA Agricultural Law section, which sponsored this great CLE program, check the ISBA website.